Welcome back to the fifth part of my video series on my book Themis. At this point in the book, we're changing direction a little bit and we're going to focus on the issue of law. Now, I'd understand if the reader's a little bit confused at this point why I make such a big detour into this different direction. But this is less a matter of my book not following a logical progression, and more about the fact that modern political theory, modern political thought has categories and divisions which don't make sense and they're not valid, but we have to adhere to them. So one of these divisions is this idea that law is quite separate from politics when it's not. And it's quite separate from things such as ritual considerations. Because this is one of the things which I discovered while I was writing the book, is that law originates from ritual orders. It directly originates from them. Now, this is something which legal scholars and those within the legal profession do not understand at all, which is something that left me with my jaw on the floor, basically, because when I went to read modern scholarship on the nature of law and its origin, I found that modern legal scholars literally had zero idea and could not understand the origin of law, where it came from, its history, or anything like that. You see that very clearly with Ronald Dworkin and with Hart as well, and with all of the others of the same type, even with British legal thinkers who are dealing with the Constitution of England. I don't think anybody in the modern period has any real understanding of the English Constitution and its history and its origin. Within the legal profession, I think they have zero idea. And you can see this when you look at the nature of human rights, because if you follow the logic of human rights and how human right law came to be, you could only come to the conclusion, if you understood the Constitution of England historically for its whole period, you could only come to the conclusion that the imposition of human rights law in 1998 was one of the most stunning, incredible derelictions of duty with regards to the Constitution and the organs of governance within the UK, the United Kingdom, to ever occur. It's quite astounding. And that's something we'll come to at a very later point. Because at this point, I want to focus on an issue where, at this point in the book, I believe that if you're someone of sound mind who's capable of following very basic chains of logical thought, A, B, C, D, I believe you should be able to come to the conclusion that modern political thought is completely incoherent because it's based upon this state of nature. If at this point you can't agree to that, you can't accept that, even though I believe I've shown perfectly well that the origin of the state of nature argument is based on complete misunderstandings of, we could say, pre-literate forms of organization, then there's not much more I can do at this point, and we just have to agree to completely disagree. And we would have to question as to why that person would be unable to make the following leap into accepting that the modern liberal political system and all of the thought based around the state of nature it just does not work. It cannot work, and it does not make sense. And to adhere to it just is completely irrational. I cannot understand it. So we just have to leave that. And now we're going on to the issue of law. Now, what I've done here is, whilst we can see the progression from Neolithic orders to the orders of places like Greece and places like Rome, when we get to the modern period, the 15th, 16th century, when the state of nature stuff was being developed, that transition from a Neolithic period to the modern period obviously isn't there, because we're way past the Neolithic period. We're past the Bronze Age, Iron Age. So we have these modern political systems which we exist in, which kind of originate in the 15th, 16th century. So then the question becomes, well, what's the connection between that and sort of sacrificial and ritual orders? Because we didn't have Neolithic orders in the Western world prior to that. We had the medieval period, early medieval period, and so forth. But actually we do have two very strong pillars of ritual sacrificial orders which our modern world is based upon. And those two pillars are Christianity and Germanic paganism. Now, if we start with Christianity first of all, not only is the issue of sacrifice present, it's central, because the death and resurrection of Jesus Christ is, if anything, the final sacrifice of Christianity. Is God sacrificing his son, and then his son being reborn, which is kind of like a rejection of sacrifice. It's kind of like rejecting the pagan process of sacrificial ritual. And we also have lots of sacrificial references in the Bible. If you go to the Bible, especially the Old Testament, you have lots of very paganistic type sacrifices with people, with animals seemingly being sacrificed, people being sacrificed, obviously, as well. And again, it carries on to New Testament with Jesus Christ's death and resurrection, which again is a sacrifice. He's the Lamb of God. Now, I don't want to keep going into too much depth on that because that's a very thorny issue and it's just not really that relevant at this point. What's actually more relevant is the issue of Germanic ritual orders, because it's from that issue that we get lots of our legal questions that have arisen in early modern periods and are still with us to this day, because the nature of the law which came from that period is a very live question. I mean, as I'm speaking at this moment, there's been talk about removing the necessity of jury trials. Now, jury trials came into being, I believe, in the 12th, 13th century because the Catholic Church outlawed the usage of trial by ordeal. Now, this might seem like a bit of a non sequitur, but it's not, because what was happening here is trial by ordeal was a method of trial where the person who was being accused was subjected to some sort of ordeal. So, for example, they would be burnt, and then what would happen after that is people would observe the progress of the healing of the burn to determine the guilt of the person in question. So if the burn healed quite well, then it was considered that they were probably innocent. If it didn't, then probably guilty. And you had trial by drowning as well, and you had different ones like that. And the Catholic Church outlawed them and instead encouraged the institution of trial by jury. These two things might seem like they're not particularly related, but they are, because you have to understand the logic that's going on behind the scenes, which is something we'll get into in this chapter. But first of all, we'd have to go for a quick bit of history of law, specifically Western European law and even more specifically English law. In the medieval period and earlier, law was not centralized at all. It was very fragmented. Different regions had their own laws. Different people were subject to different laws. It was highly fragmented. There was nothing like sovereignty as we understand it. I mean, all these different people would have been considered sovereign in their particular order, particular position within those orders. Now, the process of centralizing that law was conducted by kings. This is another area where we have pre-pronounced retrojection when we consider kings, because people in modern periods, if you talk about older kings, they kind of assumed that these kings had similar powers and authority as the modern state does now, and then they project that backwards, and then they assumed that they were like god kings and they could do whatever they want, order anything, get anybody killed, and that we've managed to temper that and become more free in the modern period when it's completely backwards. These kings in the older orders didn't have much ability to control anything, really. They were very limited to maybe their court. And the way that they managed to centralize these different laws, the different jurisdictions, was not to impose a law from the top down. What they did was they started a process where they wanted to organize all of these different laws and try and uniform them. So they didn't try to replace them. They tried to bring them all together and then analyze any differences between them and try to equalize them and bring them all together. But in different places, you had different approaches to this. And one of the approaches which developed in England was the development of common law, and that was not something which had existed since time immemorial, from like the forests of Germany. That was actually developed on development of the Norman kings, specifically Henry II was a big innovator in that. And that was a process of, again, bringing all of these different laws together and then trying to centralize those different laws in regards to the interpretation of the laws. It was not an imposition of a new legal system. That's how they first started this process. Now, if we zip forward a little bit to around the period of the English Civil War, what happened here was that the English kings and other kings throughout Europe as well were in a process of quite deep centralization. And they were quite far along the road of centralizing these legal systems. At some point, the question of who was sovereign started to develop, and that the sovereignty is completely a legal concept. This is something which gets confused quite a lot because people confuse it with questions of force, but it is entirely a legal question. So what was happening in this early modern period, especially in, again, England during prior to the Civil War, was the king was developing what was an entirely innovative state of affairs. And the other kings within Europe were doing the same thing, where they were centralizing law and then they were claiming to be above the law, to be sovereign, basically. And this is something you see from Bodin and others like him. So they were claiming the ability to create the law, pretty much. And then you had a big series of arguments whereby you had the parliaments within Europe and the nobility were disputing this, and they were disputing it on legal grounds that the law was predating the kings. This argument can be boiled down quite simply. So you've got these kings who are now claiming that they were above the laws. They were able to claim they were sovereign, basically. And then you had parliaments who were saying, well, no, laws predate you. They date back to time immemorial, way before kingship. So you're not above the laws. Laws are above you. You're subject to the laws as much as we are. And then we have the English Civil War, and then the Parliament ends up being sovereign, and the Parliament claims authority over the laws. Now, this is quite a tangled mess, and it's left people quite confused. One of the primary basis upon which this argument was carried out was over the status of Germanic law. And you see this with the American War of Independence as well, because it's quite central to the Constitution. This is something which has been made quite unclear by more modern legal scholars. And I have some ideas as to why they've done that and why that's occurred, but this is, again, yet another thorny issue which I won't deal with here. But what these people are doing, the people who are opposed to the king's claims to sovereignty, was they were going back and claiming that the law was originated from Germanic customs, which went back to time immemorial, to basically the time of like Tacitus, even further back. I mean, Tacitus' work on the Germanic tribes, Germanica, was actually incredibly influential in the early modern period because it was seen as a central source which proved this point. So that's what's happening at that point. So one of the problems which is occurring with this is that the Norman conquest kind of put a bit of a hole in this, because if you're claiming that the laws in England dated all the way back to the Germanic tribes, back into time immemorial, the invasion by the Normans in 1066 actually brought a brand new legal system. So this kind of undermines the idea that common law carried on uninterrupted, or ancient constitution carried on uninterrupted all the way back into the mists of time. So then we have this big argument about how much of an effect the Norman invasions had. And that became a big legal question. You can see that if you read the writers about the American independence at the time. They were very, very focused on this issue as well. What happened here is that we're seeing an incredibly complex process of historical interpretation and confusion going on here, where I don't think any of the parties in question come out very well. Because Well, first of all, we have the issue of retrojection. If you look at these Germans, these Germanic peoples, they were not modern people coming together in a town hall to vote on legislation. But that's kind of the interpretation which was given to them by these legal scholars, because they were looking at Tacitus's work, which depicted, I'm not sure what you call it, I think a thing or something like that, where these Germanic tribes people were coming together and they were deciding on what to do. The king didn't have any sort of real power over them. It's something you see similar in the Native American tribes, where people just turn up late, maybe they won't turn up, they'd decide whether to agree to what the chief or the king or whatever they were called was making a decision on. And if they decided no, then they would just walk off and it would be a no. But this is not, again, it's not a town hall meeting. This is a ritual. What Tacitus is detailing in his work Germanica is a ritual meeting. You could see this if you read between the lines, because there's priests present. It's done on a day which is seen as auspicious, and he doesn't describe sacrifices going on at that particular point, but that's probably because it would have been taken as granted that would have happened. He does describe other sacrifices occurring in other situations and other means of augury, but the point is that this isn't, again, it isn't a town hall meeting. These people aren't coming together and then agreeing laws, so that's a major issue from the start. But on the other hand, they are correct in that if you look at these accounts, the king is not sovereign. He isn't above the laws. The laws are predating the king in that sense. And this is kind of the basis of the argument which was occurring between Locke and Filmer at the time, because Locke's work was making the point that Filmer's argument that the kings were before law doesn't make sense, because if you look at the Native Americans, they have orders where they don't have a king, so obviously kings did not come before the laws, they have laws or whatever you. But Filmer, on the other hand, was saying that the idea that laws could come before a king makes no sense. You have to have an author for a law, so if you follow it back, all the way back, each time there must be a king before the law making the law, because that makes sense. And as far as it goes, Filmer's logic is not wrong. You have to have an author for the laws. Now, this is where a major issue arises, because actually they're both right and they're both wrong. Because, first of all, Filmer's wrong in that laws, the kings did not predate laws. Laws were there before the kings. But Locke is also wrong in that laws, while they did predate the kings, they didn't predate the sovereign. Now, you can remedy this issue by accepting that these laws originated from metapersons. At that point, we have this kind of fusion between Locke and Filmer, because Locke, first of all, because Filmer was saying that kings always predated law, or we could say the sovereign always predates the law, because the sovereign is the author of the law. Now, if you stick with just biological people, that fails, as Locke correctly pointed out. Locke was not wrong on that. But if you accept these sovereigns as not just being biological, but actually goes back into metapersons, then Filmer is correct, because it stretches back into the metaperson realm. The metapersons were sovereign, and they were the ones giving the laws. So when you see the Germanic tribes people in Germanica, in Tacitus's work, yes, the king at that point, or the chiefs at that point, were not sovereign. They were not above the laws. It was the metapersons. So when everybody's just ignoring the king at that point, yeah, that's correct. But they weren't ignoring the metaperson. And once they accepted a command was coming down from that metaperson through whatever means of augury, then they adhere to that command. It's just later in history this process occurs whereby sovereignty comes from the metaperson realm and is taken or claimed by someone who's biologically human. The process by which this happened usually was that they claimed that there were maybe demigods, half in that world, half in our world. And then eventually in history, we end up with this point in the early modern period, at least, where we have kings who are basically claiming that they were almost these metapersons completely, and they were claiming to be almost of that realm. They were taking over this sovereignty claim. And that's what's happening in the early modern period. That's why there was so much trouble. And in that case, the kings were actually innovators. They were doing something very new and very different from what actually occurred before. So while this is not something I covered in a chapter, it's something I do want to cover in this video a little bit, because it's something which I've been thinking about recently, and which it came about from the work on this book. This question of sovereignty. Now, sovereignty, again, is a legal concept. It just is. It's a question, but the precise nature of this legal question, that's a different matter altogether. Now, we can interpret sovereignty in the legal sense in two different ways. We can either interpret the sovereign as being the final interpreter of what the law should be, or we can consider the sovereign as the person or thing or body who can make the law. Now, there are two different verbs in question in play here. One is the final interpreter, and the other one is the creator. Now, this is not hair splitting. There's the distinct difference between these two approaches. If we follow sovereignty as the final interpreter, then we are still accepting that the basis of law is an external anchor to the biological people in question. Now, there are a number of different ways that this final interpreter sovereignty has developed in history. You have basic divine right theories where whoever's claiming to be sovereign is saying that they're receiving, or they're the final interpreter of what God is indicating should happen, or the gods are indicating what should happen. Or you have different ones where you have the church as being the one who's interpreting what's happening, and they're passing it along to the king. Or even popular sovereignty, which is something that Juvenal pointed out, is a species of this, because what's happening with popular sovereignty is that whoever's in governance is working from the will of the people, but the people's will is not coming from within themselves. In the general understanding of the process, I mean, what's happening there is the people are acting as conduits of the gods. So Vox Populi, Vox Dei, it's the same thing. So it still routes around to an external anchor point. Now, what's happened in modernity is, I'm not sure exactly when this happened, maybe 17th, 18th century, but you see this prevalent throughout English legal thought right now. This idea of sovereignty as being the final interpreter of what the law is, which is anchored in something external, kind of breaks down. In English legal theory, we have the ancient constitution, which we still have, and we have the idea of law holding because it originates from time immemorial. And this is, or was, it was quite a neat little trick, because what's happening here is that the question of the author of the laws was being put aside, and it was kind of like a way to hold on to this concept of laws being anchored externally without raising question about it too much, and it worked very, very well, actually. But at some point, this kind of flipped into something very different, and we start to come, I mean, you can see this in the question as regards the sovereignty of Parliament. Now, this is an open question because this is a very live question that's occurring right now, because people right now are interpreting Parliament as sovereign as being the Parliament is able to make and create laws at will, and whichever law it wants, it can override anything as it wants. Now, this is an interpretation of sovereignty which is, I think, is very much within the legal positivist tradition, where they're taking a human being as being a creator of laws. Now, there are a lot of problems with this. Primarily, it doesn't make much sense when you go into the details. It's actually an incredible misunderstanding of sovereignty, and it's a modern disease, really. It's something you see in human rights, and it's something you see in the secular rights, which have overwashed the American order as well, which has caused lots of problems for constitutional law over there. It's a very bad interpretation of sovereignty, and it's a very modern interpretation of sovereignty, and it's something which really needs to be rooted out. Parliament was not sovereign in the sense that it could just make laws at will. Parliament was always sovereign in the sense that it could interpret law. It would be the final interpreter of what the law is. And this interpretation is an interpretation of something which is coming from an external anchor point. Now, in older orders, this would have been very clearly a meta person. In later orders in England, and in Europe as well, it kind of got just pushed to being norms or from time immemorial, and just how it was always done. And we carried on from our ancient constitution, which again helped law to function perfectly well. But in the modern period, this got flipped and it became, oh no, we can make the law. We're not just interpreting the law as it already stands, we can make it. Now, if you stop and think about the logical implications of this, it becomes very bad very quickly. For example, let's say we did accept that Parliament in England is sovereign in the sense it can make and unmake any law at will, however it wished. Now, let's say, for example, right now, Reform managed to win a massive majority. They came into power and they just implemented a bunch of laws which they felt like they wanted to implement without any reference to previous constitution, previous laws, and how things have worked for 1,000 years, basically. Okay, that's all well and good. So, say, for example, they removed human rights laws, they removed all of the other laws which they're saying they're going to look at removing, based upon Parliament as sovereign being able to make and unmake laws as it wanted and create the law from nothing, like a little god, basically. Now, what happens if, after reform, a left-wing, hyper-left-wing party manages to obtain a massive electoral majority and then just undoes all of those laws and implements a whole bunch of new laws which it just creates off the top of their head? Or to take this even further, let's imagine a completely different party, a party which was devoted to murdering everybody in the country, managed to somehow magically get an electoral majority. They came into power, they issued a law that everybody has to be murdered now. It becomes completely incoherent very, very quickly. Because this idea that sovereignty is this little god, it can just make laws as it wants. And this leads you into all of these weird little situations where these things technically are perfectly legitimate. I mean, if you have a vast majority, then you could just make whatever law you want. You could make a law demanding everybody has to walk on their hands every single day, or everybody has to wear purple hats constantly. And there's no limits to this, because we've decided that Parliament is this little god that can create laws. Whereas if Parliament is sovereign in the sense that it is the final interpreter of what law should be based upon an external anchor, be it a meta person, gods, the ancient constitution, anything like that, then this issue is it's not that much of an issue, because Parliament is interpreting the law in relation to this set framework which it has to follow, it has to act within. Now, there's lots of ways you can be quite creative within that framework, and this is how law has operated for almost the entirety of human existence until modernity, when we came to this bizarre conclusion that these sovereigns were able to create and make laws at will. Now, one of the ways we can see this is, and the problems this creates quite starkly, is with human rights law and secular law more generally, because these are actually perfect examples of modern concepts of sovereignty in legal form. Because if you look at human rights law are not anchored in any external point. They're perfectly within the logic of modern sovereignty as being the creation of a sovereign being the creator of law. Because with human rights law, they're not based on God, they're not based upon any ancient constitution or any existing body of thought. They're based upon these human rights claims which just sort of appear from the minds of these human rights lawyers, or from these human rights thinkers or bureaucrats. So you have this Human Rights Declaration being created in 1945-1946 by Eleanor Roosevelt and a number of other bureaucrats. They just create these human rights off the top of their head, and then this it becomes the basis of law in human rights law in Europe. And then these human rights lawyers in Strasbourg and these other areas, they just start coming up with these new human rights laws off the top of their heads after arguing with each other a little bit. And they are basically creating law. They're making the law from nothing, basically. that's the perfect example. And if you look at the way these human rights laws have developed and the way they've worked, they're a mess. They're a complete chaotic mess. And if you start asking questions about the legitimacy of these human rights and secular rights, you start to get some very weird answers and non-answers very quickly. Like, on what basis are these rights set? They're not democratic, because you can't have human rights being democratic, in which case the universal human rights don't make any sense. So then they're unable to actually explain what they're based upon. And they try to base them on morals, but that doesn't make any sense either, because morals are not a basis of law. They never have been a basis of law, and they can't be a basis of law, because if you go into morals and ethics, there's no agreed upon ethical basis for any of this, and nobody can agree on morals or ethics. That's not a solid ground, but they pretend that it is. And you see that very clearly in people like Dworkin, who push it to that point, and then other legal scholars seem to just accept that without actually looking into ethics and morals and coming to the conclusion that that is not giving you a grounds. It's just restarting this logical argument again in a different era. Because why is it that these human rights lawyers and these human rights thinkers, why do they have a better claim to dictate what should be ethically correct or morally correct than I or anybody else? Do they have any special access to some knowledge, or do they have some special access to a meta person or an external anchor point which we can all agree on and we can all approach independently and equally? No, they don't. They just sit in a room, argue, and then they come up with these bizarre decisions which we're being forced to suffer right now. So what we're having to endure right now is actually a reopening of this argument which developed prior to the English Civil War, where instead of having kings claiming that they were the creators and makers of law and they could just create what they wanted, and having Parliament argue against this and reasserting ancient rights in the ancient constitution, in this case we have human rights lawyers and the human rights legal system claiming the ability to create laws and develop laws at will as they decide. But they've actually taken it way past the point any English king would have even imagined that they could have done back in that time. Because I can't see any of the English kings deciding that they could decide who a man or a woman was, or they could change someone from being an Afghan into an Englishman by clicking their fingers and signing a piece of paper. This is a level of control over reality which they've claimed and which they assert, which is completely new in history. This is type of claims to control over reality which meta persons would have been given and understood to have. So what you can kind of see with these human rights theorists and human rights lawyers when they're making these decisions, they are acting as if they're like little meta persons who are above and beyond the rest of us, and they're able to determine what is right and what is wrong objectively, and they're able to change the status of people by just writing it into existence. It's almost like they've got access to some sort of magic. They're so far above this, they can just do whatever they want. And the attempt to just flip this and claim that, oh no, we should be sovereign and we should have this sovereignty of in the sense of being able to make and create laws, is not a way out of this. That's just a way to keep this flipping back and forward. It's just not a way out. The only way to get out of this is to reassert sovereignty as being the final interpretation of laws in relation to the ancient constitution which we've inherited, which is what we need to do. Because if you approach it in that direction, then even if at a later point you lose power, then you can still bind whoever comes following you by this framework. Now, the problem that we've had in England, the UK, is this fight over the Constitution. We're acting like this fight has only just started now, when actually it started back in at least 1998, probably earlier, and was lost at that point. Because the implementation of human rights law into the UK constitutional system was a complete and utter disaster in this sense. Because what you've introduced with human rights law is a conception of law which does not fit with the English constitution. The English monarchy and the House of Lords should have stopped that at that point. They should have fought over that, and they should have not allowed it to be implemented, and they should not have allowed Blair's government and Parliament at that time to implement law in that sense, because it does not make sense. Human rights law is entirely alien to the English constitution, the British constitution. This constitution, which is based upon our ancient constitution dating back 1,000 years, again, you could argue that the legal scholars who were developing this were wrong in the sense that there was a break in the ancient constitution with the Norman conquest, but that actually is not a very strong argument, even though it was a one which they considered a troublesome argument at the time. Because even if you accept the Norman conquest, which did happen, did change the laws, and there were changes to the laws, it doesn't change the fact that regardless of that, the anchoring of the law was external to the biological people in question. So, but what happens with human rights law is this is completely broken with. I mean, utterly broken with. Human rights laws are not anchored in an external point of reference. They are based upon the random say-so of bureaucrats and Eleanor Roosevelt back in 1946. Now, unless you want to stipulate that Eleanor Roosevelt and the other bureaucrats who created human rights laws were demigods or higher than Jesus and they had some access to this external world, you have to accept that these are just laws which were dictated by other biological people at that point. And then if you accept that, then you have to entertain the question of why does Eleanor Roosevelt and why do these people in Strasbourg get to decide these laws? Now, again, you can't fall back on democratic claims because universal human rights laws cannot be based on democratic elections. So you have to fall back on different claims. You could say education, or you could say more moral or more ethical, or you could say, I'm not sure what argument they have because they do not put forward any good arguments for this. But none of these actually hold because we're not talking about, for example, a situation where you're comparing two different plumbers and you're saying, well, one plumber is better able at making the decision than the other because they're more experienced and they've got better understanding. This is talking about the creation of laws. That's a completely different category of thing. So there is no way for us to be able to come to a conclusion as to why one biological person instead of another should be allowed to dictate what the law is. Because there is no way to employ any evaluative criteria in that situation because there is no way to do it. That's why human rights lawyers and human rights thinkers have such problems with explaining the justification for human rights laws. Because at the very basis of human rights laws, it's just sheer will. It's just whatever that person or that group of people has decided that they want to happen at that point in time, what they want to be human right and what they think human rights should cover, that becomes the law. And that's entirely unacceptable. It just does not fit in with the English constitution. It shouldn't fit in with law anyway. In many ways, you could argue that's not law. It's just some bureaucratic demands which are emanating from some little bureaucrat somewhere or Eleanor Roosevelt's random scribblings in the UN Declaration of Human Rights, which themselves don't make any sense and shouldn't be the basis of any kind of law. She was not a meta person. She was not Zeus. She was not God. And any attempt to base it on ethics or morals falls back on the same problem. How do we determine who is making those ethical or moral claims has the ability to make those claims and to stipulate what they're saying? Are they gods? Do they have access to gods? We end up with this problem of equidistance and externality where we can't do that. We can't decide that one specific biological person has the ability to do that unless we've got some means by which to differentiate that person and place what they're claiming or saying as being coming from an external point of reference. So that's why human rights fail so spectacularly, because they just cannot satisfy any of these criteria. And it's a massively unfortunate state of affairs that this issue has been so convoluted by modernity. And I think it's legal scholars in probably about the 19th century, I'd say, people like Dicey and others like him, the legal positivists, they seem to have made this, caused this confusion. And this confusion seems to be, as far as I can tell, due to the fact that they've rejected the premise that law could be rooted in something external to biological people, and instead have tried to reconceptualize it only in relation to these biological people. And so they've basically carried on the same error which has been occurring with the state of nature argument, in which they cast out any of these external anchor points and this idea there is an external part to these orders, and then just try to reorganize it completely on an immanent basis with just the biological people, which is why you get such problems with legal positivism, where they just get tied in knots as to what a sovereign is and how to identify the sovereign. Because if you look at reality, it doesn't work like that. We don't have sovereigns in the sense that legal positivism demands. We just don't have them. And that's why, for example, I think legal positivism keeps rotating back to this idea of an external anchor point, where, for example, with Kelsen and the basic norm kind of works as this external anchor point. And you find that with other legal theorists as well, where they kind of rotate back to this external anchor point. But unfortunately, with human rights law, it just doesn't exist, and it's just something which just needs to be completely cut out from the political body completely. It's a disaster on every conceivable metric. And this is something which I'll go into more detail in later in the book. I mean, in the book, this is not covered in this detail in this chapter. I've gone on a bit of a tangent with this, but it's only because I felt that that's necessary on this video. In a later chapter, towards the end of the book, we'll cover the question of equidistance and the external anchor point that's necessary for law. And we'll look at some of the legal theories, especially in relation to rule of law, which actually has some... If you follow rule of law, if you have rule of law based upon a sovereign who can make law, as opposed to rule of law under a sovereign who can interpret the law, that becomes two very different things. Rule of law under a sovereign who can make the law becomes just basically unquestioning obedience to that sovereign, whereas rule of law under a sovereign who can interpret, is the final interpreter of law, is not unquestioned obedience. It's what we understood as rule of law, in which no single person or biological people or body can rule over all of the others. Again, that's something we'll get to in the later chapters, but for now we'll move on to the next chapter.